Good afternoon, everyone, and thank you for joining us today. My name is Eric Klein, and I am the chair of the Intellectual Property and Technology Litigation Group here at Vincent & Elkins in Dallas. I'm also happy to introduce Paige Wright, who will also be presenting with me today. Paige is a senior associate in our group and is also in our Dallas office. It's an exciting time to be discussing a topic that's not only critical to the future of the energy sector, but also to the advancement of our global economy, leveraging intellectual property during the energy transition. The world's in the midst of a profound transformation. The shift to cleaner, more sustainable energy sources is reshaping industries, economies, and societies. But behind this monumental change lies something equally powerful: innovation. And at the heart of innovation is intellectual property. Whether it's groundbreaking technologies that can reduce carbon emissions, new energy storage solutions, or advancements in renewable energy systems, intellectual property is the engine that drives progress in the energy transition. Patents and other forms of IP protection protect the inventions and processes that are helping to build a more sustainable future. Today, we're going to explore how to maximize the value of intellectual property in this evolving energy landscape, from fostering collaboration to ensuring fair access to technology, and from navigating the legal complexities to creating competitive advantages. The role of IP in the energy transition is multifaceted and essential. Our goal today is to provide you with insights into how IP can be strategically managed to not only accelerate innovation, but also to protect and grow your organization's position in a rapidly changing market. Together, we'll examine the opportunities and challenges that come with leveraging intellectual property to ensure that the energy transition is not only a technological success, but also an economic and environmental one. Over the past several years, various government programs and incentives have been created in the United States to stimulate investment in clean energy. These initiatives are designed to reduce the financial barriers to innovation, encourage the adoption of renewable technologies, and accelerate the transition to a low-carbon economy. Paige is going to tell us a little bit about some of those initiatives.
All right. Good afternoon to everyone. I'm going to walk us through a few exemplary regulations and incentives put in place to really add momentum to the already moving energy transition. The first one we'll talk about is the 2022 Inflation Reduction Act. This is a major shift in the tax code designed to expand tax credits for green technologies, including wind, solar, and several other technology areas. Those tax credits benefit companies investing in clean energy, but they're also meant to benefit individuals who invest in home improvements like solar panels or who purchase EVs. Within the first year of enactment, over 280 clean energy projects were announced across 44 U.S. states, representing over $280 billion in investment. So aside from that incentive, we can also point to the EPA's 2023 climate regulations, which introduced new technology standards for power plants and the transportation sector generally. The stated goal of the new regulations is to prevent the equivalent of more than 1 billion tons of carbon emissions. And these regulations carry with them a sizable increase in on-site inspections, climate-related criminal investigations, and civil settlements related to emissions events. We'll also talk about the SEC reporting requirements. Many of you have likely heard of this in the news. If you're familiar with this one, you know that these changes are currently pending judicial review before they go into effect, but they are certainly worth talking about here. These new rules will require publicly traded companies to account for climate pollution in their SEC filings. They'll also have to address how they're dealing with threats from global warming from a business perspective. So this new rule will create an entirely new line item, really, with respect to SEC reporting across industries. And then the last one we'll point to is the U.S. Department of Energy's funding program, which provides grants, loans, and financing programs related to green technologies. Current funding exists for developing energy-efficient technologies and renewables. And this is a federal program, but comparable programming exists at the state level through the Department of Energy State Energy Program. Oh. Okay, so we've talked a bit about regulations and incentives, but let's talk a bit about outlook as well. The U.S. Energy Information Administration projected that renewable energy generation will supply 44% of U.S. electricity by 2050, with renewable generating capacity growing in all regions of the U.S. in all cases. Specifically, they point to the combination of declining capital costs and government subsidies adding fuel to this already changing landscape in clean energy. They also point to a few specific technologies seeing a major growth spurt in the next several years. For instance, solar generating capacity is expected to grow by about 325% to 1,019% by 2050, and wind generating capacity is set to grow way as well. We also expect to see growth in installed battery capacity coupled with these growth in solar generating capacity to support the growth in renewable energy generally.
Let's talk a little bit about some of the investments in energy transition that have taken place. In 2024, the total investment in global energy is projected to surpass $3 trillion for the first time, marking a significant milestone in the sector. Notably, approximately $2 trillion of this will be directed towards clean technologies, a reflection of the growing focus on sustainability and carbon reduction. These investments will cover a broad range of technologies and innovations, including the traditional renewable energy sources such as solar, wind, and hydropower, electric vehicles and all the supporting infrastructure, nuclear power, grid modernization, expansion to accommodate more renewable energy, energy storage systems critical for managing renewable energy variability, low emission fuels such as hydrogen that can decarbonize industrial processes, and energy efficiency improvements across all sectors. The shift underscores the global drive towards decarbonization and the recognition that clean energy is essential for addressing climate change while ensuring energy security and economic growth. Governments, private investors, international organizations are all expected to play major roles in steering funds into these clean energy initiatives. In 2015, the global energy investment reached a turning point, marking the last time that investments in fossil fuels exceeded those in clean energy. Since then, the energy landscape has shifted dramatically. While investments in fossil fuels have remained relatively steady over the past decade, the growth in clean energy investment has been remarkable, driven by global efforts to combat climate change, reduce carbon emissions, and transition towards more sustainable energy systems. Some of the key drivers of increased clean energy investment include government policies and incentives. There are many countries throughout the world that have introduced policies, incentives such as tax credits, subsidies, and regulatory frameworks aimed at accelerating the adoption of clean energy technologies. Major agreements like the Paris Agreement in 2015 reinforced global commitments to decarbonization, providing further impetus for clean energy investment. There's also the declining cost of renewables. Those costs have dramatically dropped in the past 10 years, particularly solar and wind. The cost reduction has made renewables more competitive with fossil fuels, attracting more private and public investment. Finally, technological investments. Advances in clean storage, electric vehicles, and grid infrastructure have made it easier to integrate renewable energy into the global power grid. These innovations have broadened the range of opportunities for investors in the clean energy sector. Next, we're going to go to some of the intellectual property considerations. As the global energy landscape transitions toward cleaner, more sustainable solutions, protecting intellectual property has become increasingly important. The energy transition, driven by the demand for renewable energy, is sparking unprecedented levels of innovation. For companies and inventors, securing their intellectual property is essential for safeguarding competitive advantages, maximizing revenue, and supporting long-term growth. There are a few different ways that you can protect your IP during the energy transition. The first, the foundation of IP protection, is patents. Patent registration provides inventors with exclusive rights to their inventions for up to 20 years, preventing others from using, manufacturing, or selling the innovation without permission. For energy-related technologies, obtaining patents is critical to protect new materials, processes, designs, and systems. Strategic patent filing is also important. In the energy sector, it's essential to file patents in key global markets where you plan to operate, such as the United States, Europe, China, and emerging markets with high energy demands. Companies must also consider patenting in countries with storage capacity and with strong renewable energy industries or regulatory incentives for clean energy. Also, green technology patents should be considered. Some countries, including the United States, through the United States Patent and Trademark Office Green Technology Pilot Program, offer fast tracking of patent applications for technologies that benefit the environment. This can accelerate the time to market for clean energy innovations. Also, trade secrets are something to consider for protecting your intellectual property. Companies should consider protecting certain innovations as trade secrets instead of patents. Trade secrets include confidential information such as manufacturing processes, algorithms, and designs that provide a competitive edge. A trade secret is only valuable if it is kept a secret. There's no absolute right to exclude others. If a trade secret is disclosed to others, it could be lost. Also, if a competitor independently discovers the same information that forms your trade secret, they're not prohibited from using it. A trade secret can also be lost through reverse engineering. So if a competitor is able to reverse engineer a product or process, they may use it without any restrictions, so long as that information was obtained legally. With artificial intelligence systems becoming more and more powerful every day, the ability to reverse engineer a product to uncover trade secrets will become more of an issue going forward. Some things you can do to minimize the risk of losing trade secret protection include a policy of using non-disclosure agreements. So when collaborating with partners, contractors, or even employees, using NDAs is crucial to ensure sensitive information remains confidential. This is particularly important in the energy sector, where R&D efforts can span across multiple stakeholders and companies. Having strong internal controls and protocols to protect, say, trade secrets is also important. Those could include limiting access to sensitive information to only those that need it and ensuring employees understand the importance of protecting proprietary knowledge. Paige is going to tell us a little bit about some of the patent prosecution programs in the United States Patent and Trademark Office has offered for clean energy innovations.
Okay, so let's talk about one of the patent-specific incentives related to the energy transition, and that is the USPTO's Climate Change Mitigation Pilot Program. And to really understand the impact of the program, we probably need to understand a bit about patent prosecution generally. So I'm going to talk through that kind of from a high level first. Patent prosecution is the process by which inventors or companies with rights to an invention seek a patent from the U.S. Patent and Trademark Office, or the USPTO. And the owner of the invention, usually through legal counsel, will file a patent application in the USPTO, and that filing kicks off what is called patent examination, where the USPTO examines a patent application to determine if the idea is patentable. Really, the first major event in the process is called an office action, and that is a formal response from the USPTO, and generally it sets forth the USPTO's views with respect to whether or not your idea is actually inventive or patentable. And for perspective, that is not a quick process. It can take 1 to 2 years to get an office action from the USPTO. So this is not a quick turnaround, in large part because there are several patent applications in the queue for examination, and there are a finite number of patent examiners at the USPTO. So turning back to the USPTO's Climate Change Mitigation Pilot Program, which launched in June 22 for inventors whose innovations are designed to reduce greenhouse gas emissions. Qualifying patent applications are advanced out of turn to expedite a first office action. So that office action could take a short few months instead of between 1 and 2 years, basically shortcutting the path to patent ownership. The USPTO will accept applications for this program until June 27, or until 4,000 applications have been granted. Every few months or so, they put out numbers with respect to how many applications have been filed through the program. And as of now, only 1,060 petitions have been filed under the program, and 760 of those have been granted. So that means there is plenty of room for more inventors to take advantage of this program. Okay. Relatedly, we'll also talk about the Patents for Humanity Green Energy Program launched in March of 23. This is an award program recognizing inventors who use their inventions to address humanitarian challenges, including renewable energy, energy efficiency, sustainability, and reducing environmental impact. Winners of this award receive two things, the first of which is a certificate accelerating patent prosecution. That provides really the same advantage we just talked about for the last program, whereby your patent application gets to jump the line based on subject matter alone. And the second major advantage of the award is the award certificate itself. This certificate attaches to the patent, and it can be leveraged to obtain funding to roll out the invention, or it can be leveraged for compensation. So say, for example, the inventor wins this award, they can potentially sell their awarded patent for a much higher price than they may have been able to without the award, in part because of the positive publicity that comes with winning this award. Okay, so the two programs we just talked about help to bring about an increase in energy-related patent filings, but even before they went into effect, there was already a huge increase in patent application filings related to green energy. In the chart here covering the last 20 years, we see a major uptick in the number of filed patent applications with huge increases in solar energy patent applications, wind technologies, and biofuels, among others.
Let's talk next about some of the patent strategies that can be used. Obtaining patents offers several key benefits to investors, businesses, and organizations, especially in sectors like clean energy. First, the owner obtains exclusive rights to use, manufacture, sell, and license the patented invention. By securing patents, companies can differentiate themselves from competitors. This exclusive right gives businesses a unique selling proposition, which can be crucial in industries driven by innovation. We'll also have potential for increased revenue. Patent ownership provides opportunities for revenue generation through licensing agreements, royalties, or outright sales of the patented technology. Licensing the patent to other businesses also allows the patent holder to generate income without directly producing or marketing any product. It also helps in attracting investors. A strong patent portfolio can enhance a company's value and attractiveness to investors, VC capital, or potential partners. Patents demonstrate a company's innovative capability and can serve as a key asset that increases investor confidence. Patents can also be used for defensive protection against competitors. Holding a patent allows the owner to take legal action against anyone who uses, manufactures, or sells the claimed invention without permission. This legal protection defers infringement and can be used as leverage in disputes. Also can result in enhanced business reputation, such as brand recognition. A patent signals to customers, investors, and partners that a company is innovative and has proprietary technology. It can enhance the brand's reputation as a leader in research and development. It also can help with marketing and differentiation. Companies can market patented products as unique, which helps them stand out in crowded industries. Customers are often attracted to products that offer new patented features, creating a competitive edge. It also encourages further investment in research and development, an incentive to innovate. Patents provide a financial incentive for companies to invest additional resources in R&D by offering a temporary exclusive right to use that technology or innovation. This exclusive right allows companies to recover R&D costs and potentially earn substantial profits that can be used to conduct additional R&D. In industries such as clean energy and other technology areas, having patents encourages continuous innovation through that injection of capital. And by protecting new inventions, patents motivate companies to push the boundaries of technology and develop novel solutions to emerging challenges, all while protecting their investments. Patents can also lead to international market expansion, global protection. Patents can be filed in multiple countries, allowing businesses to expand and protect their innovations in international markets. By securing your patents in key regions, companies can ensure they maintain exclusive rights to their inventions globally, supporting international growth and competitiveness. With patents in place, companies can also export their technology to other markets without fear of unauthorized copying or infringement. This facilitates international trade and allows businesses to capitalize on foreign opportunities. Intellectual property as an asset. Patents are considered valuable assets that can significantly boost the company's worth. In mergers and acquisitions, a strong patent portfolio can increase the value of the company being acquired. For companies looking to sell, a portfolio of patents can make the business more attractive to potential buyers. Patents can also sometimes be used as collateral for securing loans or raising capital. Lenders may view patents as valuable intellectual property assets that can add security to their investments. It's also very common for patents to provide long-term market security. The typical patent provides up to 20 years from the filing date of exclusivity in the claimed technology. During that period, the patent holder enjoys exclusive rights, enabling them to recoup the investment made in developing the technology and build a long-term business strategy around that invention. In exchange for exclusive rights, patent holders must publicly disclose details of their invention. This promotes knowledge sharing among industry and can spur further innovation by allowing others to build upon existing technologies. Patenting also encourages collaboration. The public disclosure of patent technologies often leads to collaborations between companies, researchers, and other stakeholders, further advancing industry innovation. Patents are a critical tool for protecting inventions, securing a competitive advantage, and generating revenue. For companies operating in rapidly evolving industries, such as clean energy, obtaining patents is essential for safeguarding investments in innovation and ensuring long-term success in the marketplace. By providing legal protections, patents play a key role in driving economic and technological progress. We'd also like to walk through a new development. For some, it might be breaking news relating to one of the key rights that is afforded to patent holders that we've talked a lot about today. It's the right to exclude. Again, we've talked a lot today about how a patent owner has the exclusive right to make, use, sell, or import the patented invention for a set period of time. This exclusive right doesn't require that the patent owner actually use the claimed invention, but rather that the owner may exclude others from using it. So if a patent owner sued a competitor for infringing its patent and won at trial, the accused infringer would be enjoined from any further use of the patented invention. Before 2006, courts in the United States often automatically granted injunctions if a case went to trial. In some rare instances, injunctions were not granted prior to 2006 for reasons related to health and safety. Then in 2006, in the eBay versus Merck Exchange decision by the United States Supreme Court, they fundamentally changed how courts handle requests for injunctions in patent cases. The eBay decision introduced a more flexible approach, requiring courts to apply a four-factor test when deciding whether to grant an injunction. They were no longer automatic. Two of those factors, irreparable injury and inadequate remedies at law, I'd like to talk about shortly. The plaintiff must demonstrate that they have suffered an irreparable harm as a result of the infringement, meaning that monetary compensation alone would not be sufficient to address an injury. The plaintiff must also show that remedies available at law, such as monetary damages, are inadequate to compensate for the injury caused by the infringement. This usually means proving that financial damages cannot make up for the lost market share, customer base, or brand reputation. Some analysts believe that the end of the automatic injunction was due in part because of the increased activity of non-practicing entities. Those are companies that own patents or buy patents that don't actually sell any products. But since the eBay decision, courts have shifted more towards awarding monetary damages, such as reasonable royalties or lost profits, rather than issuing injunctions. About a month ago, a bipartisan bicameral bill was introduced. It's the Restore Act of 2024, and that is the Realizing Engineering, Science, and Technology Opportunities by Restoring Exclusive Patent Rights Act. The goal of this act is to enforce the right of a patent owner to exclude others from using a claimed invention and restore a presumption that the courts will issue an injunction to stop patent infringers. This is quite a development in patent law. If anyone has been around patent law the last 10 years, and there have been a lot of NPE cases filed, those are usually just cases where a monetary payment of some sort would be paid, and the case would usually be settled under those circumstances. The goals of this legislation, the Restore Act of 2024, is to restore the ability of all patent owners, including NPEs or those that work with standard essential patents. There's no carve out for either one of those types of entities, to obtain injunctions to stop continuing or willful acts of infringement. So this would essentially eliminate incentives for large multinational companies to commit predatory acts of infringement, especially with respect to patents owned by undercapitalized entities such as individual inventors, institutions of higher education, startups, or small or medium-sized enterprises. That is the stated goal by the senator that introduced this bill. It's also claimed to promote domestic innovation. The effects of this legislation, if passed, would be profound on patent law. As the legislation is currently proposed, again, there are no carve-outs for non-practicing entities or standard essential patents. And if this legislation were to pass as written, the threat of an injunction would be possible for every single case, including those filed by NPEs. It would likely drive up the cost to resolve these types of disputes, at least in the short term. It has yet to be seen whether there would be a similar test as the eBay test that would allow factors such as whether a company produces a product to weigh in favor or against the granting of an injunction. We are monitoring this proposed legislation, so please look for our updates in the future. It's still in its infancy, and there's a lot of negotiating to do. There is an initial push against this legislation by many of the larger companies that get involved in this type of legislation, but it is yet to be seen whether the support in the House and the Senate will be there to get this type of litigation passed. Whenever we talk about patent enforcement, it's essential to also consider the concepts of patent misuse, as it can significantly impact the enforceability and validity of a patent. And Paige is going to tell us a little about some of the pitfalls associated with patent misuse and other anti-competitive behavior.
Okay, so now that we've talked a bit about the legal trust that is a patent, and we understand more about how a patent grants the patent holder the right to operate alone with respect to a specific technology, we're going to talk a bit about patent misuse. So as you might imagine, the type of power that carries through with the patent can potentially be abused. And so this is where patent enforcement can potentially lead to antitrust issues. So patent misuse comes into play when the patent holder attempts to enforce a patent in a way that goes beyond the scope or duration of the patent, or uses it in an anti-competitive manner. So for instance, a patent holder may seek licensing fees or royalties from another entity that wants to practice their patent, and that's perfectly fine. But if, for example, the patent holder seeks licensing fees for a patent past the date of the patent's expiration date, that is a perfect example of patent misuse, because the patent holder is essentially trying to extend the life and the benefit of a patent in a way that is at odds with patent law. Another example would be seeking to enforce a patent against a technology area to which the patent obviously does not apply. That type of action would be an attempt to chill the industry potentially by enforcing an inapplicable patent, which could call into question patent misuse. For perspective, patent misuse is a particularly damning affirmative offense in litigation. So to the extent that you're looking to enforce a patent against someone or some entity in litigation, your counsel would be well-versed in the issue to help you avoid misuse or related antitrust issues. But we thought it important to mention the topic as we discussed leveraging IP within the energy transition. Okay, with that, it looks like we've come to the end of our presentation, and I think that we saw a couple of questions come through as we were presenting. So we'll take a look at those now. And the first question that came through was related to the Patents for Humanity Green Energy category, specifically whether geothermal or carbon sequestration patent applications would qualify. From the articles out about this program, it looks like the edges of the program are pretty flexible. So anything related to the energy transition, sustainability, renewables, anything kind of in that category would likely fall within the purview of that program.
Paige, I see another question. It's, does the Restore Act require that a bond be posted? I think that will be something that a trial court would take on a case-by-case basis. The act itself does not require that a bond be posted. The act itself is simply changing it's adding one portion to the patent statute on remedies that says quite literally that there is a presumption that a prevailing party on the merits at trial will be awarded an injunction. It is a rebuttable presumption, but the presumption is there that the injunction would be granted. So it would be incumbent upon the defendant to come up with reasons why monetary damages should be sufficient. So there are still going to be opportunities to do that. And if the legislation were passed in its current state, certainly it would be quite disruptive at first, but it does seem like there would be some law that was developed as that made its way through the courts to have arguments that certain entities shouldn't be able to receive absolute injunctions, or in certain situations an injunction would be inappropriate, that money could handle that and make the plaintiff whole again. Checking to see if there's a few more questions.
I see one more question related to the Green Pilot program asking, why do you think so few patents under the program have been filed? It's been 2 years. Is it not well advertised? And that could well be the problem. As I mentioned, only 700 patent applications have been granted in the program, right? And there's room for thousands more. So I do think with more advertising, perhaps we'd see more people take advantage of this, because it really is a special opportunity to jump the line with respect to patent prosecution.
Well, with that, I think we have covered all of the questions, and if anyone has any additional questions, please feel free to reach out to myself or to Paige directly. You can find our information on the Vincent & Elkins website. And thank you for taking time to talk with us today. It's been a pleasure, and we hope this was helpful for you.
Take care. Thank you.